Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Jaclyn Phillips, and today's episode is What's the Price Tag on Privacy? Turning Data Leaks into Dollar Figures. Privacy litigation in the United States is at an all-time high, owing in part to the growing body of privacy laws, particularly at the state level. In 2024 alone, nearly 2,000 lawsuits related to data privacy were brought to federal courts by litigants, and many other cases have been filed in state courts. It's not just the Federal Trade Commission and state regulators that are enforcing privacy laws, but also individuals and certified classes of individuals through the class action process. However, litigating privacy breaches poses unique challenges. And during today's episode, we'll learn about what harms arise in privacy litigation, how the concept of harm and privacy or resulting from privacy has evolved, and the challenges associated with quantifying the economic harm associated with data or privacy breaches. I'm here with my co-host, Alysha Pannu. Hey, Alysha.
Hi, Jaclyn.
Can you introduce today's guest?
Of course. Dr. Andrew Stivers is managing director at NERA, where he specializes in the economics of consumer protection and privacy. Dr. Stivers has developed and conducted analysis of novel and complex questions of consumer behavior and injury relating to privacy, algorithmically driven practices, and cutting-edge promotion and advertising strategies. Prior to joining NERA, Dr. Stivers was a senior official in the FTC's Bureau of Economics, where he oversaw economic analysis of all consumer protection and privacy matters. So he is very well positioned to speak on this topic today. He has also written and spoken extensively on topics relating to privacy and data security.
Thanks, Alysha. Hi, Andrew. Nice to have you here today.
Great to be here. Thanks for having me.
Awesome. So let's start off just generally and make sure all of our listeners are on the same page. So what is privacy harm? How would you describe it in the most simple and concise ways you can? I'm sure it's a big question.
Sure. I mean, one of the ways to think about it is simply flow of data related to me that I don't like. That covers just about everything from I didn't want a picture of me playing hooky at a ball game with my friends to go up online to I don't want my financial account information sold on the dark web.
Got it. So lots of different variations of privacy harm. Is there any type of harm that we see a lot in cases, or is it a wide range of different types of privacy harms?
People allege the full gamut. I think one of the interesting things about privacy is that when we talk about privacy, when you ask somebody, oh, hey, do you care about privacy? They're going to have any of those things, ranging from, I just think that picture is unflattering, so don't put it up on the web, to my identity might be stolen, or I might be concerned about an abusive ex-spouse finding me. So there's a whole range of possibilities there. And often the cases you see, particularly in terms of class action cases, just kind of say, look, there's privacy harms. My data related to me was collected and processed and maybe sold without my permission or unbeknownst to me. And so I'm concerned about that. And so what the actual harm that somebody can claim from that is often quite tricky to figure out.
Got it. And over the years, obviously, our lives have become increasingly more online. A lot of our data is online. We hear about different types of privacy breaches all the time. I assume that the types of privacy harms have shifted or evolved over time. Has it, if that's the case?
That's a really interesting question. I think our understanding of the range of privacy harms has certainly shifted. Early on, people weren't really aware of the ways that different kinds of data could be put together, potentially. There's a lot more effort, especially on the part of companies that might be concerned about the risk from lawsuits or legal action of some kind to try to cabin these things, to try to make sure that that sort of aggregation doesn't occur. But certainly our understanding of the kinds of information that can be extracted from very large data sets has definitely changed over time.
Typically, when we think of enforcement of privacy breaches, we think of enforcement by federal or state regulators. In recent years, in particular, and Jaclyn touched on this earlier, more states have introduced privacy laws. So there has been increased state enforcement of privacy breaches. Do you see a difference in terms of how federal and state regulators are approaching privacy harms? And if so, how do they differ?
The answer to that is evolving. Early on, the FTC, which I worked for and was, I think, the premier or the sort of leading privacy enforcer in the US, was really careful to go after the kind of most concrete, most obvious kinds of harm. So identity theft, financial information being stolen or misused, medical information being collected, personal medical information being collected and perhaps broadcast in ways that people didn't necessarily expect. So in that sense, the FTC was quite sort of focused on the low-hanging fruit of like, hey, if my financial account data is stolen, there's a high risk that, I'm going to suffer some kind of harm from that. But I think as the people's concern about privacy changed, as the state laws have changed, as the advocacy in this area has I think, become more aggressive against certain kinds of data collection, that focus on sort of the most concrete harms has shifted. I think that the availability of some of the state laws and some of the international laws allow for simply a statement of like, oh, my privacy was breached in some way, and so I'm going to claim there was some kind of violation. In many of these rules, there's statutory damages, so you don't necessarily have to show that you actually were harmed. If you can show that some sort of data was taken without your consent that relates to you and you had an expectation of it and all those other sort of legal conditions that isn't really my bailiwick, then potentially there's some sort of statutory damages awarded. So all of that means that I think the link between concrete sort of realized harms and conceptual concerns about privacy has sort of loosened. But it's an interesting question because even back when I was at the FTC, we put on a privacy harms workshop, or I should say the FTC did. Then acting chair Maureen Olhouse and sponsored that. And I was on a panel where there was a hypothetical that was put forward saying, okay, drugstore, a pharmacy collects information about you as soon as you walk in the door, right? Maybe they recognize your phone's there, they take a picture of you, there's facial scanning, whatever it is. And the purpose of the hypothetical was then to say, okay, and then they're going to do this with the data and that with the data, and they're going to collect this kind of information, sort of ask people, at what point do you think there's a cognizable harm? And immediately, some of the activists on the panel, like as soon as this hypothetical was put forward, people were like, yeah, there's a harm, right? And similar, and it's a slightly tortured analogy, but, think about, we know that drunk driving is harmful. If there's a drunk on the road, they're putting the other people around them at risk. So at what point do you sort of back up from that and say that there's actually, a harm that we at the time in law enforcement should act against, right? Is it when the person says, oh, I'm going to go to the bar this afternoon and spend 6 hours drinking with the implication that eventually they're going to get into a car, go home? Is that when we act? Or do we act more, you get into your car, you've had a couple drinks, you get on the road? And I think there's a similar question with privacy. Does the harm sort of start at, oh, you're collecting the information, which necessarily, you're going to have some increase in risk there? Or is it, well, you're going to do certain kinds of things with that information or collect certain kinds of information that has sort of a higher chance of leading to some sort of cognizable harm?
And this is sort of just a follow-up from this. Have notions of consent kind of played into how that has evolved over time? You you see all the time on online platforms, right? You're presumably signing off on some of this. And has that played into these notions of when do we act and when is there an expectation that you're giving up your privacy in some way versus your privacy has been breached because of some failure by who has your information?
Yeah, absolutely. I mean, there's a whole question of kind of expectations there. One of the interesting things from my perspective, and certainly something that, that policymakers are grappling with, is as we have become more familiar with the web, more of us go on the web, we've really become more accustomed to the fact that you can't go on the web without some kinds of data being collected from you and used in various ways, typically to target advertisements to you. We don't, in the US, typically have to give, there's no federal rule that says you have to give consent to that. Many companies, because of what's going on with GDPR and some of the sort of state mini GDPRs, have instituted that kind of consent. But when you look at the survey data, even going back to like 2010, people understand pretty well that when you go on the web and you look at a bunch of websites and maybe you're on the Nike.com website, somebody might actually send you an advertisement, say, hey, do you want a pair of shoes? Because they're tracking that kind of thing. So the expectations about what kinds of consent are required are evolving, I think, but have been sort of well known for certain kinds of data collection for a long time. In terms of other kinds of consent for, say, more sensitive data, there seems to be sort of a greater appreciation that there's, consent is required. You have an expectation that, when you type your password into your bank account, the bank account isn't going to be like, hey, here's your password.
So kind of within that same broader theme of the difference between federal and state enforcement, we also noted earlier that it's not just regulators that are going after companies for privacy breaches. There's also increased private litigation in this area. Do you see a difference in the types of privacy harms being claimed in the context of private litigation as compared to those asserted by regulators?
I don't know if I've seen enough to give a sort of categorical answer to that question. I think that there is more of a willingness by the private litigators to sort of say, let's throw everything against the wall. There's an increasing smorgasbord of state rules that they can invoke, and then let's see what sticks. I think the difficulty with that in a class action framework, of course, is that if you're pulling all these different kinds of potential privacy harms, alleged privacy harms into the mix, then you really are going to be combining things that they're not really common, right? So again, somebody who's trying to hide from an abusive ex-spouse is going to have a very different basis for and calculation of the value of privacy rather than just somebody who just says, I just like privacy. Why? I don't know. I like green spatulas too. How much do I value that? I don't know, $1 billion. Why? Because that's what I value it at, right? I mean, it's just, you bring in all these disparate, and people have very different ideas about what privacy is and why they care about it. And so trying to come up with, here is the, harm associated with a particular privacy practice that covers all these different people is quite hard to do.
I sort of preempted this question. So as kind of spin on what I asked before, just what you were talking about made me think of consent and, the difference of maybe, walking into a store and they're collecting data versus you're intentionally using, some sort of app or online platform. And I'm sure there's big variations in how consumers feel about what they've consented to and how their data is using. So does that concept and the difference in consumer perceptions impact the way you look at an economic assessment of causality, liability, damages?
Yeah, for sure. There's going to be sort of the presumption of, what kind of data is truly private and what is not. There's some real blurring of the lines as plenty of people have noted about, what it means to operate in public, when I walk down the street versus I'm browsing the internet. In both cases, you're interacting with people that aren't you that can potentially, have an opportunity to collect that information. And, we don't have that kind of consent structure, at least for those of us that aren't celebrities, where, I'm walking down the streets, I'm sort of doing my everyday performative activity, and anybody can record that on the street. And so, how that relates to activity on the web, I think has been at least a little bit murky in terms of people's understanding of it. And again, in the US, we don't have, a consent structure in place such that that's not allowed. There has been an effort by various activists and some of law enforcement, the FTC as well, to sort of institute a norm that kind of consent is required. And I think that's part of an effort to create the expectation that people will be asked for all kinds of data collection. The problem is people, routinely ignore those kinds of consents. They just sort of click through them, or they're very used to just kind of having that kind of data collected. Generally, there's some really interesting survey results that show that people know perfectly well that data is collected about them when they go online, and they also know that they have no idea what actually happens to that data. And so in that context, it's difficult to say, oh, people have an expectation. And it's important to distinguish between desire for something and an expectation for something, right? I might desire that the Starbucks coffee that I purchase is, $2 less. But if I actually go to the Starbucks, with that desire, if I actually go to the Starbucks and buy the coffee, did I really expect it to be $2 less? And furthermore, if I pay for it, am I harmed by it being $2 more, right? Certainly I prefer it to be less, but the fact that I buy it suggests that I value the coffee, more than the money. And similarly, if you go on the web, knowing that there's this sort of amorphous, really kind of undefined data collection that's going on, can you really argue that you're harmed by that, given, again, all the sort of free services and content and whatnot that we get? We might prefer that we both, have our cake and eat it too, but, it's been known for a long time that that's not really how the internet has been funded.
Got it. Well, you should set your expectations now that you've given up anonymity by appearing on Our Curious Amalgam. You're just going to be famous walking down the street now. So given that so much of this is amorphous and shifting, and there's different perceptions among everyone, I think, of what they're expecting and what they want out of kind of providing their data. So how do you, as an economist, look at these cases and even start out trying to quantify the harm from some sort of privacy harm?
Yeah, it's a question that has consumed me and a lot of my colleagues for over a decade. It's a hard question. It becomes easier the more focused the data in question is. So, for example, if we're talking about, say, breached account information about my bank accounts, then, what are the kinds of harms that we're really concerned about there? Mostly it's going to be financial harms. And so we can look at things. There's data on the risks associated with, if your password account information has been stolen, what are the risks that your account is actually going to be targeted? What's the likely, harm associated with kind of the downstream end of that, of your identity's been stolen, how much money is typically taken on average. So you can at least benchmark that kind of harm. And even in the context of statutory damages, you can at least come up with a sense of like sort of proportionally, how potentially harmful is this kind of breach. Other kinds of information becomes a little bit harder to do, but you can actually do studies. There's a technique called conjoint analysis where it involves even surveys where we very carefully, because this can go wrong if it's done incorrectly, but very carefully try to assess people's willingness to pay for certain kinds of privacy. As you can imagine, people are sort of say they're more willing to pay for privacy surrounding their kids or their financial information or their medical information, as opposed to say, what kind of spatulas they like. So you can, again, with a very specific or more specific kind of context, get a more precise valuation of sort of how much people are willing to pay for these things. Of course, the problem that you always have in this sort of survey-based approach is that, it's like the Starbucks example, right? If you say, well, how much do you care about paying, $6 as opposed to $4 for a cup of coffee? People are like, oh my God, it's the worst thing ever. So you have to try at least to put in people's heads the kinds of trade-offs that they might be willing to make or might have to make in those situations. The other way that you sometimes see people try to calculate harms is they try to appeal to sort of an IP sort of information ownership structure. So the idea is, I make a movie, I license it to various theaters or maybe some bars that they show the movie. And if you show the movie without my permission, without licensing it with me, then that's a lost sort of commercial opportunity to me. And so we can sort of estimate how much money I would have made had you actually gone through the process of licensing. The problem with that is that there's not really a market for individual people's data. Data is valuable typically sort of in bulk. There used to be this analogy that was popular, data is the new oil. There's one that sort of superseded that, which is data is the new sand, which kind of emphasizes like it's valuable in lumps, big lumps, but not necessarily individually. But even within that, there's this real question of like what kinds of data are actually being paid for and in what context. And in terms of like my ability to monetize my data, it's really hard unless I'm willing to do some kind of Nielsen level, I keep a diary and you get to survey me and you really understand who I am as a consumer and then track like everything I look at on the web. Because often these services, and I don't know about Nielsen in particular, but often these services that do sometimes pay consumers to be part of sort of a market study, you have like a tracking device on your home internet. So like everything is being collected. So they have a much more comprehensive picture than, say, a NERA slice of, what websites was I, visiting today on my particular device.
So you mentioned that data is it's more valuable, can be seen as like sand. And so when there's aggregate data on individuals seems to be more valuable. But I presume that there might be some unique challenges with quantifying economic harm, particularly in the context of a class action. Can you maybe explain what some of those challenges might be?
Sure. I mean, the big one I alluded to before, which is in a sort of general claim about privacy violations, so many people are coming to the table with so many different views about privacy. Like, what data are they concerned about? Where do they go? What kind of data was collected? Because everybody has different stuff that they do online. What kinds of practices did they employ to mitigate those concerns, right? So somebody might have 16 different email accounts and they have a different one for each website they look at or sign into. And, maybe they even use a different device for certain kinds of web browsing versus other. I have a work device that I try not to do any of my personal shopping on with some limited success. I still get the tracked ads because I'm like, oh, right, I did actually go visit that website to make that purchase just during the day. So all of those different behaviors, concerns, and then, of course, beliefs, like what did you actually expect? All of those things vary. So trying to understand, first of all, what people were trying to accomplish, what level of privacy they actually were expecting, related to what, and about what, trying to come up with, here is sort of the way to calculate privacy harms across the entire class, for example. It's just really hard to do. You've got just so many variables. And it's hard, again, in that sort of general context to say, here's the way to sort of calculate harm for each of these potential members of the class. Of course, if we're doing things with law enforcement, the FTC doesn't care about any of that stuff, right? They often, when I was there, they would take a much more focused approach they would also potentially say, oh, you paid a certain amount of money for some product with the expectation that sort of part of that product was privacy, right? Just like you purchase a car and the steering wheel is kind of integral to that. If you pay money to a company for, say, to hold your money in a secure account, part of that is holding an account secure. So the question is sort of, how much did you pay for that? Would you have been willing to pay for that absent that security? In the case of the bank account, probably not. And then trying to figure out, and again, there's statistical methods for evaluating, what sort of price premium might be associated with a privacy attribute or security attribute.
Thank you, Andrew. This has all been very interesting and sounds like there's still a lot to learn as we continue to see these cases. And I'm sure the way that plaintiffs allege these damages are going to evolve, and, defendants' breakdown of them will as well. Yep. So I'm sure you'll be at the forefront of that. Before we let you go, we want to ask you some questions to get to know you better. So tell us something about yourself we wouldn't know just from working with you.
So much. So I used to work for the United Farm Workers back in college.
Doing what?
Basically handing out leaflets on the street. And then also I was an organizer for Cesar Chavez's funeral because he passed away while I was working for them. And I was the one of the celebrity wranglers. So Joan Baez, who is a singer-songwriter of great repute, has called me dear on the phone, which is one of my treasured memories.
That's a good fun fact. And one more, since we're talking about privacy today, what is your most used non-work related app?
YouTube.
YouTube. Okay.
And I pay for premium, so I don't have to watch the ads.
I'm trying to stop his habit before it continues. Awesome. Well, thank you so much for joining us today.
It's been a pleasure. Thank you for having me.
And to our listeners, see you next time on our Curious Amalgam.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org. Antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.